What options do I have if I've been ordered deported because my immigration attorney made a mistake on my case? Hi, I'm Jim Hacking, immigration attorney practicing law here in St. Louis, Missouri. Every now and then we're approached by people who have been ordered deported at the immigration court, and they're wondering if their attorney made a mistake. We definitely review cases for people to take a look at them for them. We've done a lot of analysis for different people who've come to ask for a second opinion to see if a mistake was made in their case. A lot of people come to us and they're angry with their prior attorneys. In the vast majority of the cases, the attorneys did everything right, and there's not much that we can offer to them in terms of an appeal or a motion to reopen or some kind of extraordinary relief like that. There is a mechanism, though, in immigration court for people who have been wronged by the carelessness or the mistake of their attorney, and that's called filing an ineffective assistance of counsel claim. Now, you have to know that once you've been ordered deported, there are strict deadlines on filing for other forms of relief, like motions to reopen based on ineffective assistance of counsel, or if you've been ordered deported in absentia, which means you were ordered deported because you missed a court date or you weren't in court. Generally, you have 90 days from a general order of removal to file a motion to reopen or reconsider with the immigration judge. And if you've been ordered deported in absentia without being in court, you generally have 180 days. And these are pretty strict deadlines to file motions to reopen or to reconsider. If you were ordered deported because of the ineffective assistance of counsel, you might be able to get around those deadlines, but you should do everything you can to comply with the deadlines if possible. Okay, so if you want to make an ineffective assistance of counsel claim, how do you do it? Well, there's sort of 3 steps to it, and the immigration courts take a very harsh look at these, and you have to comply with the rules because they're very strict. The first requirement is that you sign an affidavit that sets forth what happened in your case and why you think that your attorney was ineffective. You have to list all the reasons why you believe that your attorney screwed up your case and how that prejudiced you, how that caused you harm, how that would have changed the result if the attorney had done their job properly. Not only do you have to sign that affidavit, you also have to forward it on to the attorney that you claim screwed up your case and give them the opportunity to respond. So the way you do that is you package together your affidavit, you let them know about the motion, and you give them the opportunity to send a response in with you. The third thing you have to do, and this is the hardest part of the whole prospect, is you have to actually file a bar complaint. The Board of Immigration Appeals and immigration judges got tired of individuals making claims of ineffective assistance of counsel without them also filing bar complaints, and they thought that these were being filed as a pretext in a way to sort of get around the requirements that you show that you shouldn't be deported in the first place. And so they've put this requirement that you have to actually file a bar complaint with the state bar where the attorney is licensed and give them the opportunity to respond there. Those are the 3 Lozada requirements. You also have to show the prejudice that I mentioned earlier. You have to demonstrate that the result would have been different if the attorney had done his or her job effectively. You know, when I was a new immigration attorney, we came across an ineffective assistance of counsel claim at the very outset. And that case was so egregious that I thought all ineffective assistance counsel claims were relatively easy. And I've since come to learn over the years that they're actually pretty difficult to make. You can't just assume that because an attorney might have made a little mistake that the court's going to reopen and undo the deportation order. Ineffective assistance counsel claims are very hard to win. And I will tell you the story about the first one that I had, though. A young man came to see me. His wife was in jail and had been ordered deported because she did not appear in immigration court on her court date. The reason she did not appear in court on her court date was because her attorney never told her about the court date, and she was ordered removed in absentia, that is, without her being there. Now, her particular attorney had some interesting things going on at the time. He had been a state representative here in Missouri, and he had run an immigration practice on the side, so he sort of had 2 competing things going. The other issue for him was that he had been indicted by the federal government to punish him for running an immigration scam. He had been creating fake visas for his other clients. A trucking company had created employment visas for them, and the feds had come after him hard and charged him in federal court with immigration fraud. By the time my client had been ordered locked up, this attorney had been disbarred, and sentenced to jail. So I actually had a lot of evidence of his ineffectiveness, and that led us to file this motion to reopen based on ineffective assistance of counsel. We complied with the rules. We filed the affidavit. We gave him the opportunity to respond, which he didn't do because he was in jail. And we also filed a bar complaint. So having complied with each of those orders, the immigration judge reopened the case, and our client ultimately ended up getting her green card because by that time she had long been married to a U.S. citizen. She had an approved marriage application, and but for the attorney's ineffectiveness, she would have shown up to court on her court date and not been deported. So obviously we were happy with that result, but you have to know that these are hard cases to make. You have to comply with each of the requirements of the case. The main case on point is called Matter of Lozada. You have to comply with each of the Lozada requirements in the hopes of getting an ineffective assistance of counsel claim in front of the judge. If you have any questions about this, you should definitely talk to an immigration attorney. These are complex matters that are fact intensive. They need a lot of evidence, and you need to argue the law as well. So you're definitely going to need an immigration attorney for an issue like this. If you have questions or want to talk to me about this, feel free to pick up that phone and give me a call, 314-961-8200, or you can email me, jim@hackinglawpractice.com. Thanks.